Hello. This is a summary of the main points from the second tutorial. There are three key areas that we covered. The first was about the basic work of lawyers. And that involves, firstly, interpreting statutes, and secondly, applying case law. So, as a future lawyer, you need to be able to read statutes and understand them, and to be able to read law reports and to apply them. Now, I've sent some handout material about interpreting statutes, how to read an Act of Parliament, and so that's something that will come with practice. The second, reading law reports, again, the more law reports you can read, the better your ability to understand them. And of course that's related to the whole issue of judicial precedent. So make sure that you understand the concepts of binding precedent, persuasive precedent, and the task which is central to legal argument, that of distinguishing. That's where a case is argued to be a binding precedent, but it's argued that there is something different which makes the precedent inapplicable. The second issue that we looked at were principles of the legal system. And what I did was to put people into working groups, collecting information and condensing it, and this again is something that you can do at home, on the three topics of judges, courts, and legal personnel. The work that needs to be done between now and the next tutorial is to look at the procedures in criminal and civil cases. And the best way to approach that is by drawing flow diagrams and making sure that you can identify who does what and when, and then to go and consider why. The other issue is the jury system. Now, what I did was to encourage a debate about whether it was a good thing or a bad thing. This is something to think about for future exams. Would you be in a position to be able to argue both sides of the argument? And the best way for preparing for that is to list down those key points addressing the strengths and the weaknesses of the arguments on each side. The third thing that we looked at was ETMA 01. First of all, some general comments. Read the question and the advice on answering the question, because when I come to market, that's what I will be judging your answer against. I've seen far too many essays put in which answer the question that the student would like to have asked, but I can only credit the actual question asked and how you've responded to what it demands. So read the question and that advice on answering the question. Have a look at the marking bands criteria. Again, I have to use that in deciding which band is appropriate. It's not a percentage mark, it's within those bands. If you look at that, you'll see the criteria that I have to find sufficient evidence to come to my conclusion. So if you know those, you can gear your answer to the band mark that you want. Make sure that you use legal argument. If you make a proposition of law, back it by authority. So if you're going to say that there is a duty of care to to the users of a manufacturer's products, your authority is Donoghue and Stevenson. And write for the intelligent but non-specialist. Don't try and blind by lots of legal sounding argument. That's something the Law Society is very concerned about. Your aim is to communicate, not to baffle. I mean, imagine that you're dealing not with me, but with your future client who needs complex ideas explained in a straightforward and understandable way. Question 1. To answer this, you need to define the four sources of law and explain. Give examples. Compare. Particularly, what happens if two sources conflict? And it's very important for the final part of that question. So legislation, both primary and secondary legislation, case law, European Union law, and human rights law. So define and explain. The second part of the question involves problem solving. It means applying your knowledge to the facts before you. I say the worst thing that you can do is write all I know about a particular subject rather than directing it to the question set. So explain the consequences of the facts, the distinctions between criminal and civil liability, both concepts, guilty and liable, and the consequences. Make clear the distinctions between criminal and civil procedure. And as I say, use the facts to explain the law, not all I know about the difference between civil and criminal, because that is not the question. Well, all the best, and hope to speak with you soon.